Hello, this is Jim Lange, and in this video series I have talked about the death of the Stretch IRA, and I kept saying subject to exclusion and there are exceptions. So now with this video I am going to talk about the exclusions and the exceptions to the 5-year rule. So the biggest and probably most important exception is the 5-year rule, or the death of the Stretch IRA, will not apply to your surviving spouse. So if you are married and you leave your IRA or your 401k or your 403b or whatever type of retirement plan you have to your spouse will be able to continue the tax-deferred feature of the IRA the same as existing law. So that is the biggest exception, and that is a wonderful protection for our surviving spouse. The next exception is charities and charitable remainder trust. And you might say, well, gee, Jim, I wasn't really thinking of leaving the majority of my money or even a significant amount of money to charities or charitable remainder trust, so that's not that big a deal. But it's actually a bigger deal than you might think, because in a different video series, I'm going to be talking about the benefits of naming a charitable remainder trust as the beneficiary of your IRA, and prove to you that even if you aren't charitable, for not everybody, in fact actually a relatively few number, but that will actually be more beneficial to your children under the proposed law than if you just leave it to them outright. So the fact that the charitable remainder trust is excluded from the 5-year rule is actually strategically very important. The other thing is, another exception is disabled or chronically ill beneficiaries. They will not be subject to the 5-year rule. The other one is minors. So let's say that you die and you leave your IRA to a grandchild. Although we always advocate that you leave an IRA not to your grandchild, but to a well-drafted trust that meets the 5 specific conditions in order to qualify as a designated beneficiary of an IRA to your grandchild. Under the proposed legislation, your grandchild will be able to continue to stretch that IRA, the same as existing law, until they reach their majority, which in Pennsylvania at least is age 21. In different states it's different ages, maybe even 18. But when the grandchild, or any minor for that matter, reaches their majority, boom, that starts the 5-year clock ticking. So let's say that you leave it to a 10-year-old. They can take the same minimum required distributions of the inherited IRA as existing law from age 10 to 21. Then from age 21 to 26, they're going to have to take out the entire inherited IRA, have to pay income tax on the full amount. So the exception for minors isn't really all that helpful because they get nailed when they are 21 years old. All right. Another exception that I think is helpful is in the event that your beneficiary is within 10 years of your age. So who would that likely apply to? Obviously not to children or grandchildren, but that would apply to maybe siblings. It might apply to unmarried partners. So that is a useful exception. The other exception, or to be more accurate, exclusion, is each IRA owner will get one $450,000 exclusion from the death of the Stretch IRA. So what does that mean? Let's say that you die with a $1,450,000 IRA and you leave it to your son, who is your sole beneficiary. What that means is the son could take $450,000, which is the amount that he is allowed to exclude from the death of the Stretch IRA, and he can continue to defer the income tax just like the law is right now. Unfortunately, for any amount over and above that, which in this case would be $1 million, he will have to pay the income tax on that entire $1 million within 5 years. So that's pretty miserable, but at least we have this $450,000 exclusion. Now, one of the bad things about this exclusion is that you cannot pick your beneficiaries and say, okay, we want to use the exclusion for the Roth IRA for the grandchildren, for example. No, you have to prorate both the Roth IRA, and you have to prorate among all the retirement plans, and you have to prorate among the beneficiaries. So all the fun that, frankly, I thought we were going to be able to have with, let's say, having special beneficiaries getting certain parts of the exclusion, we can't do that. The exclusion has to be prorated throughout. On the other hand, for as much as I'm complaining that you have to prorate, at least it's nice that we do have this $450,000 exclusion. Thank you. If you are interested in more information on this topic, we actually did a 1-hour webinar just on the death of the Stretch IRA and what happens to your IRA after you're gone and what you can do about it. And what you see below is a link to the webinar. So if you click on the link, that will lead you to the webinar, and then you can watch the entire webinar at your leisure. It's about, well, it's actually a little bit longer than an hour. And if you do that, that will also give you access to a whole bunch of information, all of which, by the way, is free. But we have several books available for free, including our flagship book, Retire Secure, which is still doing well on Amazon, even though it's, I think, 2 years old. And our newest book, which is The Ultimate in Retirement and Estate Plan for your $1 million IRA, and the Social Security book, and lots of other goodies for free. So I do urge you, take the time. I think it'll be very valuable to watch the webinar and take advantage of some of the other free resources that we have to offer. Thank you.